Maar ons begin met die Kill the Boer hofuitspraak. Die Gelykheidshof het verlede week beslis daar is nie genoeg bewyse om te bevind dat die sin van die lied op haatspraak neerkom nie. Die hof het gesê die struggle lied moet gesien word in die politieke konteks waarin dit gebruik word. AfriForum het die aanvanklike aansoek gebring vir 'n interdik om die EFF en sy leier Julius Malema te verbied om Kill the Boer te sing. Om verder hieroor te gesels, sluit 'n grondwetkenner Adv Ben Winks nou by my aan. Ben, so how would you explain this judgment to a person in very simple terms who might feel very emotionally about this case?
Well, there are a couple of things to clarify about what song exactly the case was about. So most of the reportage has been about Kill the Boer. Now those words don't actually appear in the chant as it is now. Julius Malema stopped singing Kill the Boer, or in fact it wasn't even Kill the Boer, it was Shoot the Boer, Dubulibunu, in 2011 after a previous Equality Court proceeding. And from then on he began singing Kiss the Boer. So this particular song, or chant rather, is shoot to kill, kiss the Boer, kiss the farmer. What was put to him is that kiss is coded language for kill, and I think that's not a huge logical leap to make. I think it's fairly obvious that that's what's meant. But what was argued by the EFF and by their expert, who was an expert in language and an expert in struggle songs, was that it's not meant to be taken literally. So firstly, kill is not literally meaning violence, it's meaning to defeat a system. And Boer is also not meant literally to mean white people or Afrikaanse people, but means the system of oppression, the system of disenfranchisement, dispossession. So the court found that on that level of meaning, that does it refer to a racial group? The court said no, because it's not meant to be taken literally. And does it amount to a call for violence? No, because it's not meant to be taken literally. And that's where the court ultimately made its decision.
So the court said in the current political situation, the songs are directed at articulating the current government's failures in addressing the issues of economic empowerment, land reform and distribution. So I'm just playing devil's advocate. What if a new political movement or party is started and they start singing Kill the Zimbabwean or Kill the Mozambican, and they say, but the intention is not literal. They don't want to kill, or they're not asking for the murder of any foreigners. It's simply an expression against the current government's failure to act on illegal immigration, for example.
It's a very good question, because a lot of the debate in hate speech jurisprudence revolves around this question of intention. Now, the language of the law is a bit confusing because it says that it's hate speech if, to the reasonable person, it appears that the intention is to cause harm or to propagate hatred. Now, there's a mixture there of an subjective question of what is the intention of the speaker, but the courts have been quite clear that in fact the subjective intention of the speaker doesn't matter. It's what the objective observer would think the intention of the speaker is. So it's a bit of a confusing concept to wrap one's head around, but there have been cases where this has been applied. Use the same reasonable man test as you would use in defamation law, as we have for 200 years. To determine what is the objective meaning of the words in their context. Now, it's a question then of how not only the target group, the group that is demeaned by the speech would react, should reasonably react, but how people outside of that group would react. Will the speech make them hate that group? Will the speech make them develop some kind of animosity to that group, or would it even make them contemplate violence against that group? So one looks at how it would affect society at large as objectively as possible.
Do you think the Equality Act is clear enough on what exactly hate speech is?
It isn't, but it's hard to imagine how it could be made much clearer, because you're dealing here with speech. And our law around speech, like defamation law, like the law around inuria, which is where you harm someone's dignity using speech, is already very vague, because you can't, language is so fluid, it can appear in so many different contexts and different forms. It can be speeches, symbols, cartoons. It's very difficult to prescribe in a detailed list what boxes something should tick to amount to defamation, for example. So you speak in general terms. Does it lower the esteem in which that person is held in society? So then you'll look at a particular word and say, if I say that this person is a crook, is that defamatory? That's the first question. In most contexts it would be, but in other contexts it won't be. And then you look at justification. So the same would apply to hate speech, where you'd have to see objectively, is this advocating harm? The acid test really is, does it dehumanize people on the basis of a group membership? That really is where I would articulate the test. When you look beyond the verbose language of the act, does it dehumanize, does it degrade people on the basis of the group they belong to? And that, I think, is a question that courts can answer when applying to particular facts.
So would you say those were the grounds that led to the same court delivering a judgment saying that the old flag is considered hate speech, but singing a song saying Kill the Boer, Kiss the Boer, which you've just explained is perhaps coded language, but that is not hate speech?
This is exactly the thing. And another case that I would mention is the case where leaders of Black First, Land First had on social media said, thank the ancestors for killing these land thieves, in reference to the death of 4 children who happened to be white in the collapse of a bridge at Hoërskool Driehoek. Now that didn't involve any incitement to cause harm to anybody. It was simply, but dehumanizing people purely on the basis of their race. So it was deeply degrading to white people as a group, makes them feel unwelcome in the country, makes them feel less human. And that is rightly found to be hate speech. Now, unfortunately, what in my view, strategically and also legally and jurisprudentially, a mistake that AfriForum has made is that they have taken the view, in opposing the old flag case for one, and in other contexts, they've said, no, in order to be true hate speech, there has to be a call to action, there has to be incitement. I don't think that's correct, and I think that the law has become very clear that that's not correct. But having pinned their colours to that mast, they then had to meet that standard in the case they brought against the EFF around this Kill the Boer case. And so they had to set up this case to meet that there had to be a call to action, that you're actually trying to reach people's minds to commit violence. And the evidence of the EFF's witnesses, including their expert witness, is that there's no call to arms here. It's not meant to be taken literally. And on that basis, they lost the case.
A lot more to discuss, but that's all we have time for, Ben. Thanks so much.
Thank you for having me.